2011 was the America Invents Act. This was the biggest act of Congress concerning patents in 175 years, since 1836, and it is still being implemented, and some of the biggest parts of it are still being implemented now to go into effect in March. So here's the party over the signing of the America Invents Act. Obama and all these leaders, they did this at Thomas Jefferson High School for Science and Technology. The Patent Reform Act of 2011, known as the America Invents Act. It makes a lot of changes. The one that most people are conscious of is that even now, the U.S. is under what's called a first-to-invent system. So in the rare situation where two parties both invent basically the same thing, and they both file patent applications around the same time, what is now done is what's called an interference to determine, it's a formal legal procedure to determine who was the first inventor. Under the new first inventor to file system, which is the standard in all the rest of the world, the first one to file is going to get the patent. So there's an encouragement. What's your quid pro quo? You disclose the technology in return for getting a patent. And what the system wants to incent is the disclosure of the technology. They don't want people to hold it back and keep it secret. They want to disclose it. And then that encourages other people to design around it, to improve on it, and at the end of that 20-year term to use that technology. There's a lot of other aspects of the American Invents Act. I'm not going to go into all of those now. So what is necessary now and previously and even more in the future is a sense of urgency. There could be a race to the patent office to beat out competitors. You have to file an application before you go public, or you will lose patent rights in most of the world. That's true now, and that will continue to be true. If you publish something today, you've lost all of your rights to ever get a patent in Germany or China or Korea, because they all have a requirement called absolute novelty. The U.S. is almost alone in having a one-year grace period. That's a subject that is going to be even more of a hot topic in international negotiations. Most countries like to keep things the way they've had things before, and the U.S. basically unilaterally moved towards this first-to-file system on the theory that it's a better practice. So let's adopt the best practices. And other countries were very visibly, I meet with these international patent attorneys, and they were visibly pleased that the U.S. is making progress in that area. So when is the right time to file a patent application? I get a lot of calls every day from people who say, I have an invention. No, actually they don't say that. They say, I have an idea. Okay, that's great. Somebody called me several years ago. They said, I'd like to put the controls for the radio on the steering column. That kind of tells you how long ago that was. I said, that's great. How does it work? Well, I don't know, but it would be great if I could do it. Now, if you teamed up that person, kind of maybe a Steve Jobs-like person, with one of the engineers in this group, they might have been able to figure out how to do it. As it turned out, I saw an ad in a magazine the next day that had exactly the same thing, so I called the inventor back and said, don't bother. But when is the right time? The right time is when you've tested the prototype in secret and you plan to go to market. You know you're going to roll that product out. You know that you're going to be submitting a publication. Jim Oliver's got a new technology. He's going to publish it in some scientific journal. He wants to get a patent application on file before that article becomes published so that he can preserve his international rights. Would you have patented the digital computer? There was only going to be a need for two of them. So Aton Assoff invented the first digital computer in the 1930s at Iowa State. He wrote up an invention disclosure. No patent application was filed. Who was asleep at the wheel? The only sure way not to get a patent is don't file for one. This has to do with the timing of the American Invents Act. There's more stuff going on in Congress. From 1790 to 1836, there were 10,000 U.S. patents issued. In that era, every U.S. patent was signed by the President, the Secretary of State, and the Attorney General. I'll show you an example of one, an image of one. Today, okay, so that was 10,000 patents in 46 years. Now, 10,000 patents are issued every 2 weeks. That's how fast the rate of change is, the rate of development in technology. This is an image of a patent to William Harris, a citizen of the state of Massachusetts, who invented a new lathe or loom for weaving. This patent was signed by John Adams, president, in the city of Philadelphia in 1800. It's also signed by the Secretary of State and the Attorney General. So so far I've been talking about what Congress has been doing with patents. That's the legislative power. What happens with the executive power? All three branches of our federal government are actively involved with patents right now. The U.S. Patent and Trademark Office is the federal government agency responsible for patents. That's within the administration. The Undersecretary, how's that for a title? The Undersecretary of Commerce for Intellectual Property and Director of the United States Patent and Trademark Office. That's David Kapos. He's formerly of IBM. Very highly respected. He's going to be stepping down in January 2013, and most patent attorneys, including myself, will be very sorry to see him go because he's a very competent guy. He's an engineer himself. He understands technology and he understands patents. There are 8,000 examiners in the U.S. Patent and Trademark Office. I have lived in towns smaller than that, and they're divided into all kinds of different technologies. Here's David Kapos speaking. He's a very good speaker, and this is the uspto.gov website. I recommend this to you. There's a lot of good information there, including search capabilities. It's a little hard to download patent images unless you download a free TIFF viewer that they provide. Another source for getting patents is Google Patents. How many of you have ever seen a patent? Quite a few. How many of you have a patent? How many of you have applied for, or if you don't have one, have applied for one? So it's good to see a patent, just to see what they look like. Jim Oliver, stand up. I want you to notice two things about Jim Oliver. One, he's a handsome guy. But another thing is he's mortal. And he has gotten patents, and you can get patents too. They're not just for rocket scientists. Thank you, Jim. The judicial power, the U.S. Supreme Court, the U.S. Court of Appeals for the Federal Circuit, the U.S. District Courts, they're all very actively involved in deciding patent cases. This is a photo that I have. It's autographed by all the judges except Judge Davis, who's at the front on the left. He was in ill health, and he actually did not live long after this picture was taken, but I have autographs of all the other judges. Many of these were original judges of the Federal Circuit, which was created mainly to provide uniformity in patent law across the United States. So all appeals from the U.S. Patent and Trademark Office and all district courts across the country, including the Southern District of Iowa, the Northern District of California, Florida, Montana, they all go to the Federal Circuit in Washington. I clerked for the judge in the back row, third from the right. He's the tall, balding man, Edward S. Smith. Great guy, and that was a great experience. Again, speaking of culture, there's a culture within a court. Courts are people. Judges are people. And that's probably the main thing that I learned from clerking there. You know, you don't just submit your data to a computer and have the computer crank out the result. Judges are very hardworking, they're very diligent, they're very smart people, but they are people. And they have to be treated with respect, among other things. And it can be a challenge to explain patent cases to judges. Most of them do not have a technical background, but they're very smart and powerful people. So you have to be able to explain technology without going into a lot of technical words. The judges don't want a postdoc in organic chemistry. They don't want that. But sometimes you have to give them almost that much information for them to be able to decide the case. And that's a great challenge.